All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good afternoon, everyone. Court officer, could you call the case, please?
Good afternoon, Madam President. This is the situation in Darfur, Sudan, in the case of the prosecutor versus Abdallah Banda Abakar Nourain. Case reference ICC 0205-0309. And for the record, we are in open session.
Thank you very much, court officer. I will now take the appearances, please, beginning with the Office of the Prosecutor. Ms. Brady.
Thank you, Madam President. I appear today with Senior Appeals Counsel Helen Brady, Puru Sachitanandan Trial Lawyer, Niftiru Appeals Counsel, Associate Trial Lawyer Rachel Mazzarella, Catherine Dunmore, Trial Lawyer, Carmen Garcia Ramos, Case Manager, and I am Cara Prunk-Jordan, Senior Legal Coordinator for the Office of the Prosecutor, representing Deputy Prosecutor Khan, who unfortunately can't be here today.
Thank you very much. I will now take the appearances for the defense, please. Chief Tucker.
May it please Your Honors. My name is Chief Charles Achaleke-Taku, Legal Counsel of the Banda. I appear today with my learned colleague and co-counsel, Mr. Thomas Obof, and my case manager, Ms. Judith Akebe. Thanks, Your Honor.
Microphone, please. Chief Tucker.
Yeah, I'm sorry, my lord. General Banda is following the trial by video link from Khartoum. General, welcome, and I apologize for not mentioning your name earlier. I think your presence here today will also is very, very important, and for me in particular. I really cherish that you should be here and listen to your lordships by serving the prosecutor and the victims. Thanks.
Thank you. The Chamber notes the appearance of Mr. Banda 12 years after his failure to appear and the issuance of an arrest warrant. I now turn to the legal representatives of victims, please, for the appearances.
Oui, bonjour, je suis Maître Hélène Cissé, conseil principal. J'ai avec moi Maître Jens Dickman, conseil associé, et Madame Evelyn Ombeni, case manager. Merci.
Thank you, Ms. Cissé. Now, the registry, please.
Madame la Présidente, Messieurs les juges, bonjour. Pour représenter le greffier aujourd'hui et en l'absence de Marc Dubuisson, directeur des services de la Cour, Charlotte Dahuron est accompagnée de collègues de l'unité de coopération judiciaire et du bureau du directeur. Merci.
Thank you very much. This hearing is scheduled for a single session this afternoon, and it is a public hearing in open session. The purpose of this status conference was set out in the Chamber's decision on the prosecution's request for reconsideration and the defense's request to convert the warrant of arrest into a summons to appear. As stated in paragraph 29 of that decision, the Chamber, in the circumstances, directed the prosecution to provide public notice of its withdrawal of the charges, together with the reasons for that decision. Following the prosecution's statement, the legal representatives of victims and the defense will have an opportunity to make oral observations should they wish to do so. I wish to emphasize that the parties and the participants must restrict their submissions and observations to this procedural matter before the Chamber this afternoon, which is the prosecution's withdrawal of the charges. The Chamber will not entertain statements or observations relating to substantive matters on the case. With those remarks, we will now hear from the prosecution.
Thank you, Madam President, Your Honours. I will begin with a short introduction, and then Mr. Sachitanandan will provide a more detailed overview of the reasoning of the prosecution. And after this, I will briefly conclude the remarks of the prosecution. Madam President, Your Honours, the prosecution appears before the Chamber today to give notice publicly that it is withdrawing the charges against Mr. Banda. A notice of withdrawal was filed this morning. We do so because it is the prosecution's carefully considered view that the evidence no longer presents a reasonable prospect of conviction at trial, and that the evidence has deteriorated so much so that it even no longer demonstrates that there are substantial grounds to believe that Mr. Banda committed the charged crimes. This is not a decision that has been taken lightly. It is a decision grounded in the legal and ethical obligations that define the office and in our continuing duty to act independently, fairly, and in the interests of justice. The pre-trial chamber confirmed the charges against Mr. Banda 15 years ago in 2011. The prosecution has since undertaken a continuing and rigorous reassessment of the evidentiary record, exhausting all reasonable investigative avenues available to it. As Mr. Sachitanandan will explain further, this case and the decision to withdraw have been the subject of careful internal review and consultation across the office. The decision is the product of thorough professional analysis, considered judgment, and faithful adherence to the prosecutor's statutory responsibilities. Having undertaken that assessment, the prosecution no longer has confidence that the charges continue to be supported by the evidence or that it can discharge the requisite burden at trial. The prosecution has a duty to proceed to trial only where it genuinely and reasonably believes that the evidence establishes guilt beyond a reasonable doubt. Moreover, the prosecution owes an equally important duty to victims not to foster expectations of a conviction where, following careful reassessment, the office no longer has confidence that the evidence can sustain one. To continue in those circumstances would neither serve justice nor honour the trust that victims have placed in this court. Your Honours, the prosecution fully recognises the impact that the withdrawal of the charges will have on victims and affected communities. We also recognise the Chamber's view that this case could appropriately proceed to trial. We respectfully acknowledge that difference of view. However, the Rome Statute entrusts the prosecutor with an independent responsibility to continually assess the evidentiary basis of every case and to proceed only where the legal and ethical standards governing this office continue to be satisfied. The integrity of the criminal process requires prosecutors to act with objectivity at every stage of proceedings. In this stage of proceedings, we have a duty to pursue cases only when we believe that the charged crimes can be proven beyond reasonable doubt. Our duty is not simply to prosecute. It is to ensure that prosecutions are pursued only where they can be properly and fairly sustained. And it is for these reasons that the prosecution withdraws the charges against Mr. Banda. I now hand over to Mr. Sachitanandan.
Madam President, Your Honors. Pursuant to your instructions, I will set out the reasons underpinning the prosecution's withdrawal of charges against Mr. Banda. I will discuss principally the main evidentiary developments and the related reasons why the office has maintained that the continuation of proceedings would no longer be consistent with its obligations under the Rome Statute. You will recall, Your Honors, that once the charges were confirmed in this case, the proceedings advanced to the trial stage and trial was initially scheduled to commence in 2014. However, Mr. Banda failed to appear pursuant to the summons issued by the court, and the trial chamber then issued a warrant of arrest in September 2014, and Mr. Banda remained outside the court's custody thereafter. Importantly, even though Mr. Banda remained at large, the office continued to discharge its obligations under the Rome Statute. The prosecution continued to investigate both incriminating and exonerating evidence or circumstances, remained in contact with witnesses wherever possible, and continually reassessed the evidentiary foundations for the prosecution case. Your Honors, during these reassessments, a number of problematic developments arose in the evidence. These developments principally affected one key aspect of the prosecution case, that is to say, the issue of whether Mr. Banda was aware of the factual circumstances establishing the unlawful nature of the relevant attack. These evidentiary developments are as follows. Firstly, the loss of witness P441. Your Honors will recall that P441 occupied a significant position within the prosecution case because the witness provided evidence concerning Mr. Banda's position of authority within the attacking force, and also regarding Mr. Banda's access to information regarding the planning and execution of the attack. Later prosecution investigations, however, revealed that P441 had engaged in serious dishonest conduct. As a result, despite the importance of his evidence, the prosecution determined that it could not rely on such testimony, since such testimony could not be regarded as credible or reliable. Accordingly, P441's evidence could no longer form part of the prosecution case. Similarly, Your Honors, there was the loss of the evidence of witness P477. P477 had also occupied a central position within the prosecution case, in that the witness provided direct evidence concerning the purpose of the attack and Mr. Banda's position of authority. His evidence supported at that time the inference that Mr. Banda possessed the requisite knowledge of the unlawful nature of the relevant attack. However, Your Honors, during renewed contact with the witness, significant credibility concerns arose. Ultimately, the witness refused to further engage with the office. Here again, the office therefore concluded that P477 could no longer be relied on as a credible prosecution witness. The consequence hereto was the loss of one of the principal sources of evidence capable of establishing the reason for the attack, the unlawful nature of the attack, and Mr. Banda's knowledge of its unlawful nature. Your Honors, the prosecution did not accept these developments passively and sought to remedy these weaknesses. To do so, the office undertook extensive investigative efforts. Previously interviewed witnesses were recontacted where possible, and investigators systematically reviewed available new leads. There was a comprehensive mapping exercise which identified known participants in the attack, and potential witnesses were identified. These potential witnesses were approached wherever possible, and in particular, individuals believed to have key evidence relating to the planning of the attack were sought. a number of these new witnesses were interviewed. Madam President and Your Honors, it is at this time or around this time that the investigation took another important turn by way of the location of witness P512. P512 had not been interviewed during earlier stages of the investigation, despite prolonged and extensive efforts to find him. However, the office was finally able to secure his evidence and found that he was a credible witness whose account materially altered the evidentiary picture. Whereas the prosecution had previously relied upon the absence of any attempt by the attackers to locate the Government of Sudan representative within MGS Haskanita as supporting its case theory, by contrast, P512 described attackers as actively searching for this Government of Sudan representative, Captain Bashir. This evidence substantially weakened the prosecution's previous inference regarding the purpose of the attack and introduced a credible alternative explanation. Overall, Your Honors, viewing in retrospect this process of investigation or reinvestigation, the efforts of the prosecution to fill the gaps in its case ultimately proved unsuccessful. Key potential witnesses were either deceased, could not be located, declined to cooperate, or were unable to provide evidence capable of remedying the identified deficiencies. In addition to these challenges in the context of newly identified witnesses, in the 15 years that had elapsed since the pretrial chamber had confirmed the charges, several of the witnesses relied on at the confirmation stage had also become uncontactable, uncooperative, or otherwise unavailable. Of the confirmation witnesses that remained available, some presented credibility and reliability issues, and the prosecution necessarily had to exercise caution in relying upon their evidence, especially when they provided the sole or main evidence on a given fact. Your Honors, bearing all of these factors in mind, and having undertaken a significant effort to reinvestigate the case, the office carried out an internal evidence review in February 2023. This review included experienced prosecutors, investigators, and analysts from across the office of the prosecutor. After extensive review and consultation, the resulting assessment completed in March 2023 concluded that there was no reasonable prospect of convicting Mr. Banda on the available evidence. Given the significance of this finding, the office considered it appropriate to introduce an additional safeguard. Accordingly, Madam President and Your Honors, Deputy Prosecutor Nazat Khan instructed that an independent external review take place. Thereafter, an experienced external advisor reviewed the evidentiary record and submitted his report in September 2023. In his report, he also independently concluded that the probability of securing a conviction was low. Your Honors, it is against this backdrop, after extensive efforts to reinvestigate the case and equally extensive efforts to effectively analyze the evidence, that the prosecution finally, in October 2023, sought authorization from this chamber to withdraw charges against Mr. Banda. Your Honors will recall that the chamber first rejected the application in October 2023 and invited further submissions. Among the reasons provided by the chamber at that time were, inter alia, the fact that Mr. Banda remained a fugitive from justice. Following additional proceedings, the chamber once again declined to authorize withdrawal in March 2024. Your Honors, with regard to the period after such rejection, the office did not cease investigations. Rather, it continued searching for evidence capable of overcoming the deficiencies identified during its review. Those further efforts, however, ultimately reinforced the officer's conclusions. Your Honors, 2 additional witnesses, that is to say P1840 and P0308, were identified as potentially capable of providing evidence, direct evidence, concerning planning meetings which may have been relevant to proving the unlawful nature of the attack and Mr. Banda's alleged knowledge of such unlawful nature. However, once interviewed in late 2025, both witnesses proved unable to provide the anticipated evidence. Neither had attended the relevant meetings, neither possessed direct knowledge of the planning process of the attack, and in addition, one witness relied upon hearsay evidence or hearsay information from unidentified sources, and the other presented additional reliability concerns. Therefore, far from strengthening the prosecution case, these interviews confirmed that the remaining reasonable investigative avenues had effectively been exhausted. Subsequently, Your Honors, you will recall that in October 2025, the counsel for the defense submitted a request to convert the arrest warrant for Mr. Banda to a summons to appear. At this point, the prosecution assessed that Mr. Banda's appearance before this court was potentially imminent. The office in this context recalled the Chamber's earlier guidance that once Mr. Banda's appearance had been secured, relevant matters could be reconsidered. The office again at this point bore in mind the exhaustion of investigative remedies as represented by the interviews of P1840 and P308. Thus, in November 2025, the prosecution renewed its request to the Chamber to reconsider its decision not to authorize the withdrawal of charges. The prosecution at that time was of the view that, firstly, compelling Mr. Banda to appear for trial when the prosecution had already concluded it could not prove the charges would amount to an injustice. The prosecution was also of the view at that time that it would also create unrealistic expectations amongst the victim community, this community who had been waiting for over a decade for the trial to commence. And indeed, Your Honors, as the prosecution appears before you today, it remains still of that view. I note, Your Honors, that it is subsequent to these submissions of the prosecution and other parties and participants that in June 2026, the Chamber authorized the prosecution to withdraw the charges without prejudice to future proceedings and to give public notice of such withdrawal. Madam President, Your Honors, this concludes my provision of detailed reasons for the withdrawal of charges. I now hand over, or rather hand back to Ms. Pronk-Jordan.
Madam President, Your Honours, as you heard in the overview that was just provided, since the confirmation of charges against Mr. Banda, key prosecution evidence has deteriorated, credible exculpatory material has emerged, and renewed investigative efforts have failed to restore the evidentiary foundation of the case. As a result, the prosecution has concluded that it can no longer responsibly maintain its case. The prosecution respectfully takes note of the critical observations by the Chamber in its decision to authorize the withdrawal of charges. However, as mandated under the Rome Statute, the prosecution's responsibilities require it to independently assess whether it remains proper to continue advocating for a conviction. Moreover, while the assessment of witness credibility and reliability at trial is ultimately a matter for the trial chamber, the prosecution cannot knowingly present evidence from witnesses whom it no longer considers sufficiently credible or reliable. Today, the prosecution is not seeking the easier course, but the course that the law and our professional responsibilities require. In doing so, we fulfill our duties to the accused and to the victims and seek to uphold the integrity of these proceedings. Justice demands not only that serious crimes be prosecuted where the evidence permits, it also demands integrity from the office to discontinue proceedings where, after careful and exhaustive review, the legal and ethical standards required of this office are no longer met. The prosecution's withdrawal of the charges is without prejudice to bringing new charges on the same or similar facts should we obtain sufficient evidence in the future. Because our overall work in the situation in Darfur continues. It continues with our work in cases pending before the court over past atrocities, and it continues in our ongoing investigations into current crimes in Darfur. Throughout this investigation, the office has met with victims and survivors. We have listened to their accounts, learned of the profound suffering they have endured, and witnessed the remarkable courage they have shown in coming forward and engaging with the office. Nothing in today's submissions diminishes their suffering, the seriousness of the alleged crimes, or the importance of their search for justice. Thank you.
The chamber takes note of the statements of the prosecution. Next, we will hear the observations from the legal representative of victims.
Your Honours, may it please the court, I will start the oral observations for the legal representatives of victims to be continued with principal counsel. Your Honours, today this chamber is asked to note the prosecution's withdrawal of charges against Mr. Banda and is asked in consequence to terminate the proceedings in this case. But respectfully, it is not merely terminating a case. By doing so, it is closing a chapter in the lives of men and women who have waited for almost 19 years for justice. For them, for the participating victims in the Banda case, this is not a procedural application. This would be, in fact, the end of hope. Hannah Arendt, based on her own experience as victim of fascism and her own political theory, famously described, quote, the right to have rights, end of the quote, as a central, in the fact, essential human right. All systems working under the rule of law like this court are bound by this human right and its promise. Our clients believed that the International Criminal Court represented precisely this promise. When every national institution failed, when no government protected them effectively, when violence had erased the health, their life of the beloved sons, the husbands, the brothers, and their dignity, they believed over all the years that international justice still recognized them as human beings whose suffering mattered. Today, many of them will inevitably ask us, did we really have that right? Or was it only an empty promise? Justice has always required patience, sometimes extraordinary patience. But justice also requires perseverance from all actors. In this context, the legal representatives of victims remind the chamber to its public decision on the prosecution's request for finding of non-compliance from 19 November 2015. On 16 October 2015, the Office of the Prosecutor requested that the Chamber issue a finding of non-compliance against the Republic of the Sudan in the Banda case. Prosecution submitted that Sudan has failed to implement the court's order to arrest Mr. Banda and that there is no prospect of Sudan complying with the arrest warrant of its own volition. On the 9th of November 2015, the legal representative of victims filed a submission supporting the prosecution's request with 4 confidential annexes containing letters, handwritten letters from represented victims, where they supported the relief sought as quoted in Chamber's decision in footnote 3. Legal representatives of victims had collected several authentic personal handwritten statements. The request was granted and the decision was transferred to UN Security Council. So the individual pleading of the victims is part of the record of this case. The victims remind us, especially today, international criminal justice exists precisely for those moments when success appears impossible. Your Honors, every judicial decision speaks also beyond this courtroom. Every decision sends messages, if we want or not. What messages will today's decision send? What messages want we to be sent? The first message may sound cynical. It may be heard by defendants at large. It may be heard by suspects who consider escaping justice. The message could become painfully simple, and it's, if you can evade arrest long enough, justice eventually disappears. Flight may pace, time defeats accountability. That is a very dangerous lesson of today. But it must be said loud. Justice delay may be justice denied. A second message reached beyond this court. It reached the African Union. The participating victims in the Banda case have been African Union peacekeepers or working for them, heavily wounded and handicapped for life, and the families, widows and children of peacekeepers who have been killed in the Haskanita camp on this terrible day in September 2007. Brave men served under African Union mission, risked and sacrificed their own lives to protect civilians in Darfur and fighting for peace and security in the region. What are we telling the African Union today? Is the ICC a place to effectively protect African Union peacekeepers against international crimes? What do we tell those brave soldiers believing that international justice stood behind their sacrifice? And finally, Your Honors, talking about messages, let us send out a message to the victims today. Let us remember the participating victims. Let us send a message to them today, not as files or witness numbers or procedural participants. The participating victims in the Banda case, they are the true heroes of these proceedings. They testified, they cooperated with the prosecution and the court. They realized unimaginable suffering. They believed in law instead of revenge. Their patience has been greater than ours. Their courage has been greater than ours. And their faith has certainly been greater than ours. Your Honors, history rarely remembers procedural orders. History remembers what institutions stood for. Nuremberg was never only about convictions, whereby the first judgment was rendered on 1st October 1946, 80 years ago this year. Nuremberg was about declaring that law would replace impunity. this court carries the same responsibility. Whether today's application is granted or not, history will ask a larger question. Did the International Criminal Court in this historical situation remain faithful to its promise that no victim would ever again stand completely alone? That is a question which will echo far beyond this courtroom. On behalf of our clients, the 103 souls from 6 different African nations, the participating victims in the Banda case, the legal representative of victims wish simply to express our profound gratitude to everyone who has devoted years of their life to this case, the registry, the court, and particularly also the office of the prosecutor. Their work during the past years honored the victims. But I address the prosecutor. You will only truly honor the victims if your work continues also with regard to the Haskanita incident, because justice delayed may wound hope, but justice abandoned wounds humanity itself. So there is one message of the participating victims to us in this courtroom today. And this message is with the words of the late Benjamin Ferencz, words which should continue to inspire every institution committed to international justice. Never give up. Never give up. Never give up. May it please the court. This concludes my own observations. I respectfully hand the floor over to Principal Counsel, Maître Hélène Cissé. Thank you.
Merci. En fait, nous avons tenu à ce que l'accent soit mis sur les souffrances réelles, l'attente, les espoirs des victimes, avant d'entrer sur le débat technique. Parce qu'en fait, on a l'impression que les victimes sont les orphelins de la justice pénale internationale, et en particulier dans cette affaire. Je voudrais, avant toute chose, remercier la Chambre d'avoir invité les représentants légaux des victimes de présenter leurs observations orales sur cette question du retrait des charges demandées par le procureur et autorisées sur des conditions et des circonstances très spécifiques. Dans la foulée et nous avons pu constater la volonté de cette Chambre de permettre aux victimes d'avoir une participation active, peut-être malheureusement plutôt au stade final depuis 2011 en fait. Donc, les observations que je souhaiterais simplement compléter, c'est de dire que dans la foulée de l'excellente présentation et de la situation contextuelle des victimes, il est important de garder à l'esprit que le droit d'avoir des droits, c'est avant tout le droit de les exercer pleinement, concrètement, au stade de la procédure appropriée, mais selon les intérêts et les besoins personnels des victimes aussi. Ces droits leur sont garantis par l'article 68.3 du statut de Rome, sur lequel, bien entendu, je ne reviendrai pas. Mais je veux dire tout simplement que le droit essentiel impliqué dans la procédure du retrait des charges demandées par le procureur de toutes les charges et accordé par la Chambre, c'est, comment dirais-je, une procédure qui est aussi au cœur des intérêts personnels des victimes, même si dans la tradition anglo-saxonne de common law, on a plutôt tendance à penser que c'est entre les mains du procureur d'une procédure accusatoire que reposent les débats pratiquement exclusivement et que les victimes ont très peu à dire leur mot. Or, comme la Chambre a eu à le souligner avec pertinence, le système ayant vocation à l'universalité de la Cour pénale internationale a accepté et intégré deux systèmes juridiques très différents. Le système de common law, purement accusatoire, et le système civil romano-germanique qui revêt un aspect plus inquisitoire, mais qui donne une participation plus effective aux victimes, y compris dans les matières de preuve. La conférence de mise en état, je le dis donc et je le répète, porte essentiellement et exclusivement sur l'autorisation qui a été donnée par la présente Chambre au bureau du procureur de retirer toutes les charges contre l'accusé. Nous avons eu à le dire et à le répéter. La conséquence automatique, c'est de dénier aux victimes le droit à un procès public. Et c'est de ça qu'il s'agit. Et c'est pour ça qu'il est important que les représentants légaux des victimes fassent leurs observations sur les conditions dans lesquelles ce retrait des charges a été accordé. Nous avons constaté l'innovation de cette Chambre qui, contrairement à beaucoup d'autres décisions antérieures, n'a pas hésité à examiner non seulement les problèmes procéduraux spécifiques au retrait des charges et au pouvoir du procureur et de la Chambre, mais qui a insisté sur un point capital, c'est que, et il semble, et c'est pourquoi je souhaite le souligner, que ces aspects des décisions répétées de la présente Chambre ont été totalement occultés, oubliés par le bureau du procureur. À savoir que la Chambre a autorisé le procureur à notifier le retrait des charges, mais qu'elle a eu à rappeler ses décisions antérieures d'octobre 23, de mars 2024, selon lesquelles elle estime que, quant à la substance, la requête au fin de retrait des charges devant annuler toute possibilité de procès public n'était pas justifiée. La Chambre, même dans cette décision du 26 juin 2026, a répété qu'elle n'était pas d'accord avec le procureur et a répété qu'il existait de nombreux éléments pouvant constituer des charges permettant d'aller au procès. Évidemment, on n'a rien entendu de cela aujourd'hui. Mais ça, c'est important pour mesurer l'injustice que représente un retrait des charges alors que la juridiction saisie confirme et répète qu'il y a des charges qui permettent de poursuivre un procès. Et quelle est la motivation de la Chambre? Et c'est cela qui constitue vraiment un problème particulier. La Chambre, après avoir répété qu'elle n'est pas d'accord avec le bureau du procureur, parce qu'il existe bel et bien de nombreux éléments de preuve permettant de soutenir les charges, et je me réfère à toutes les indications données par la Chambre et les chambres antérieures, comme la Chambre préliminaire pour la confirmation des charges, la Chambre, lors de la décision d'octobre 2023, refusant le retrait des charges, du 6 mars 2024, refusant la considération. Cette fois-ci, quelle est la raison pour laquelle la Chambre a décidé d'autoriser le retrait des charges? C'est le motif suivant, et c'est cela qui désarçonne complètement les victimes, et elles ne peuvent pas le comprendre. Qu'une Chambre dise qu'il y a des charges qui existent, mais que le fait que le procureur décide de ne pas soutenir l'affaire ne permet pas en réalité d'envisager un procès sans violer l'équité par rapport au procureur. D'abord, je soulignerai qu'alors que l'impact essentiel est porté par le déni du droit des victimes à un procès public, on ne dit rien sur l'injustice pour les victimes d'arrêter toute possibilité de procès uniquement parce que le bureau de procureur estime qu'il ne peut pas aller au procès parce qu'il estime que il considère que les charges ne sont pas suffisantes pour entrer en voie de condamnation. Et là, nous pensons qu'il y a une injustice grave et qu'il y a également le non-respect, la défaillance du bureau du procureur dans les devoirs et obligations essentielles qui d'ailleurs ont été rappelés par la Chambre, qui découlent de l'article 54 du statut. Au terme de ce statut, au terme de cet article, et c'est cet article-là qui prévaut, et pas l'article 60 du règlement du bureau du procureur, qui d'ailleurs n'a même pas été pris en considération par la Chambre. Et cet article dit bien que le procureur a l'obligation de faire toutes les enquêtes possibles et nécessaires, de réunir tous les éléments pouvant aider la juridiction à déterminer s'il y a des bases pour la mise en œuvre de la responsabilité pénale de l'accusé comparant devant lui, en particulier en ce qui concerne les charges fondées sur l'article 8 du statut de Rome. Et c'est ça qui est important. Et ici, il est très important de souligner que même dans un système, malheureusement pour nous, représentants des victimes, et pour nous, venant d'un système romano-germanique, où moi-même, en tant qu'avocat de l'ancien président Hissène Habré au tout début de la procédure, j'ai pu constater le rôle déterminant des victimes dans le rapport des preuves lorsqu'elles sont allées au-dessous de la piscine pour ramener des éléments de preuve capitaux qui ont permis à la Chambre extraordinaire de l'Union africaine d'entrer en voie de condamnation. Donc je dis que c'est très important. Et je considère qu'on ne voit pas, d'abord qu'il y a un problème à éclaircir. En priorité, le droit au procès des victimes. Je ne parle pas des échanges qui précèdent le procès, mais le droit inaliénable, fondamental, sans arrêt répété par toutes les autorités politiques, juridiques du monde entier, le droit des victimes à avoir un procès, à avoir droit à un débat judiciaire. Et c'est de là qu'il s'agit. Pour demander le retrait de toutes les charges, le procureur, en fait, on n'arrive même pas vraiment à saisir quelle est sa position par rapport à ce droit au procès judiciaire et au débat. On sait seulement que le procureur dit sans arrêt qu'il considère qu'il n'y a pas suffisamment de charges pour entrer en voie de condamnation. Mais le droit au procès judiciaire, c'est quoi? C'est d'abord d'aller au procès. Et est-ce qu'on peut considérer que le procureur se donne le pouvoir, nonobstant les obligations très claires de l'article 54 du statut, de dire, en fait, il ne dit même pas « je ne vais pas au procès ». Il dit « je ne peux pas soutenir ». Mais le devoir du procureur, c'est de participer au procès judiciaire, de participer au débat judiciaire public, d'exposer ses convictions, quelles que soient ses orientations, même si c'est pour dire qu'il estime que les charges ne tiennent pas. Dans beaucoup de législations, les procureurs se lèvent et parfois disent « je ne vois pas d'éléments tendant à fonder la culpabilité de l'accusé, par conséquent, je demande la relaxe ou l'acquittement ». Ces mots n'existent pas dans le vocabulaire, mais la procédure est la même. Est-ce que l'on peut interdire tout procès public qui est la finalité du droit des statuts à l'accès à la justice, uniquement parce que le procureur continue à dire « ah, je pense que je n'ai pas assez de preuves ». Non, il doit assumer ses responsabilités. il va au procès. J'ai cru comprendre qu'on lui avait même suggéré d'aller au procès. Il va au procès, il exprime ses convictions, y compris quand elles vont vers le sens qu'il estime qu'il n'y a pas matière à culpabilité parce qu'il n'y a pas suffisamment de charges. Mais il y a procès. Il y a un débat judiciaire. Les autres parties, les participants peuvent intervenir. Et comme l'a rappelé la Chambre, dans l'exercice de ses pleins pouvoirs juridictionnels, notamment de l'article 64, c'est la Chambre qui décide. Ce n'est pas le procureur qui décide, il n'y aura pas de procès, parce que je ne suis pas convaincue qu'il y a matière à procès. Il peut l'exposer, mais ce n'est pas à lui d'empêcher un procès, parce qu'il dit qu'il ne va pas soutenir. Et là, pour nous, c'est un aspect essentiel, parce qu'on n'arrive pas à comprendre même le contenu de la décision et le contenu des déclarations du procureur. La décision dit qu'il n'y a pas de sens à aller à un procès quand le procureur refuse de soutenir le dossier. Mais en fait, si le procureur, il a l'obligation d'exprimer ses réquisitions, ou quel que soit le vocabulaire, même s'il estime qu'il n'y a pas matière à culpabilité. Donc, en fait, les victimes ne comprennent pas. Elles ressentent comme une profonde injustice le fait qu'on arrête toute possibilité d'un procès, tout simplement parce qu'on constate que le procureur considère qu'il n'y a pas assez de matière pour soutenir des charges. Il n'est pas dit expressément qu'il ne va pas aller à l'audience, qu'il ne va pas assumer ses responsabilités. Il dit qu'il n'y a pas assez de charges. Et la Cour répond, puisque le procureur ne veut pas soutenir, nous, on ne peut pas remplacer le procureur et les victimes non plus. Mais le problème, c'est quoi? C'est le droit au procès judiciaire public. C'est le droit du débat contradictoire sur les éléments de preuve et autres éléments de la situation contextuelle. C'est aussi le plein pouvoir juridictionnel inhérent à toute juridiction. Et en ce sens, peut-être que mon confrère développera, il y a des décisions du tribunal pénal international pour la Yougoslavie et du tribunal pénal international pour le Rwanda qui disent clairement qu'il est nécessaire de pouvoir donner plein effet, plein pouvoir juridictionnel qui est inhérent à l'impérium du juge. Et que même si ce n'est pas clairement stipulé dans les statuts fondateurs de la juridiction, si les juges estiment que c'est une nécessité vitale pour leur plein accomplissement de leur devoir, de leur pouvoir juridictionnel, eh bien, ils ont un pouvoir créateur. Et tout le monde le sait, la jurisprudence a un pouvoir créateur. Et je crois que la Cour pénale internationale est l'un des meilleurs exemples du pouvoir créateur jurisprudentiel des chambres, et parfois même pas dans le même sens. Vous voyez. Donc, la question, elle est là. On est en face d'une situation où, et bien que le procureur le passe sans arrêt sous silence et semble l'ignorer, où il lui a été clairement dit par la juridiction qu'il y a des éléments pour soutenir les charges. Et même l'article 60 sur l'éthique n'a même pas été retenu. Donc on est dans une situation pour les victimes où la chambre qui rend la décision dit « Ah oui, il y a matière à poursuivre, il y a des charges, donc il faut continuer le procès ». Mais finalement, on ne peut pas le continuer parce que le procureur ne cesse de dire qu'il ne peut pas soutenir. Mais ça veut dire quoi? Le procureur, il va à l'audience, il exprime ses convictions, les autres parties et les participants et les victimes, en particulier les victimes à statut duel, qui sont nombreuses et qui pourraient donner des éclaircissements incroyables sur les accusations proférées par la défense contre la mission d'Ascanita, parce qu'ils étaient opérateurs eux-mêmes de radio, et ils savent ce qu'il en était de communiquer ou non avec le gouvernement du Soudan, puisque c'est ça l'essentiel pour la défense. Je dis qu'il y a là une incompréhension. Nous ne comprenons pas le raisonnement d'abord de la Chambre tenant à dire on autorise le retrait des charges, il y a des charges, mais on autorise le retrait des charges parce que le procureur ne veut pas, soutenir ces charges. Mais est-ce que c'est compréhensible? Comment peut-on supprimer le droit des victimes qui ne cesse d'être proclamé par tout le monde? Tout simplement parce que le procureur ne veut pas justifier sa position dans le cadre d'un procès public. Et c'est là où nous disons qu'il y a pour nous une erreur dans le raisonnement, parce que je ne vois rien dans le statut de Rome qui permet au procureur de faire arrêter un procès avant même le procès, parce qu'il s'estime qu'il n'y a pas assez de charges, mais qu'il exprime au procès et qui permette un débat judiciaire. C'est ça la règle de l'état de droit. Et s'il y a une cour de laquelle les victimes, le public attend énormément sur l'état de droit, c'est bien ça. Donc nous estimons qu'il y a une erreur dans le raisonnement, parce qu'on ne voit pas sur quel fondement, le seul fait que le procureur dise « Ah, je pense qu'il n'y a pas assez de charges », eh bien, il n'y a pas de procès. Non, il faut un débat judiciaire. Il faut permettre aux victimes qui, quand même, ont le pouvoir de présenter, même si elles ne se substituent pas. Mais la présidente de chambre a eu à le dire souvent. Certes, le procureur est le maître des poursuites, mais nous, juridiction, nous avons le pouvoir et le devoir d'estimer la force probante des éléments, de prendre en considération l'ensemble de façon holistique avant de prendre une décision. Et c'est ce deuxième point qui choque les victimes par rapport à ce retrait des charges, c'est que tous les éléments, pour la plus grande partie exposés par le procureur ce matin, ils ont été rejetés par la Chambre. Décision d'octobre 2023, 6 mars 2024, et il n'y avait que 2 éléments nouveaux, 1840 et 308, P1840 et P308. Tout le reste, P477, P441, P512, avaient déjà été rejetés par la Chambre. Donc nous disons que nous estimons qu'il y a une erreur dans le raisonnement, parce que rien ne permet d'arrêter un procès simplement qu'avant le procès, le procureur estime qu'il n'est pas convaincu. Mais qu'il le dise dans le cadre du procès et que ça soit débattu. C'est cela. Et deuxièmement, nous avons compris que la Chambre a estimé que ça serait une violation de l'équité et de la justice par rapport au procureur. On aurait presque envie de dire « nul ne saurait se prévaloir de sa propre turbitude ». On ne veut pas comparaître à l'audience, on ne veut pas de débat, on ne veut pas de procès, mais ça ne peut pas être opposé comme argument de l'état de droit, des règles de l'état de droit, à des victimes qui ont tellement souffert. Et je le dis ici pour compléter mon confrère, dans ce document comportant les charges, le procureur n'a cessé de dire que bien qu'il n'y ait que pas trop de victimes par rapport aux crimes de masse auxquels on est habitué, il est vital pour l'avenir des missions de la paix, de maintien de la paix, que ces crimes de guerre soient jugés. Donc ce n'est pas parce qu'il y a des milliers de cas dans un autre cas du Darfour qu'on expédie ce cas-là et tant pis pour les victimes. Non, tout être humain, toute victime a la même valeur. Et je dirais que dans l'état de tourmente de l'Afrique et du monde, dans l'état de difficulté et de non-respect du droit international actuel vis-à-vis même des missions de maintien de la paix, il est plus urgent et nécessaire que jamais de comprendre l'importance de cette affaire. C'est la première observation. La deuxième, donc, c'est les conditions. Donc nous estimons et nous sollicitons, nous souhaitons que la Chambre veuille bien nous autoriser à introduire une requête en reconsidération pour erreur dans le raisonnement, parce que dans les règles de procédure, nous ne voyons pas comment il est possible qu'on arrête un procès alors qu'on estime qu'il y a des charges, uniquement parce que le procureur, avant le procès, dit « Ah, moi, je ne suis plus convaincu ». Mais qu'il le dise et qu'il y ait un débat. Deuxièmement, il y a une injustice. Moi, je le dis, j'ai été tellement choquée de voir qu'aucune référence, pas un mot, par rapport à l'injustice que serait pour les victimes de leur dénier le droit au procès. Par contre, ah non, on ne peut pas être injuste vis-à-vis du procureur. Mais le procureur, c'est son devoir. C'est son devoir. Les victimes, c'est leur droit au procès judiciaire public. Et c'est de ça dont il s'agit. C'est ce que je voulais dire, et que donc on sollicite l'autorisation de faire une requête aux fins de reconsidération sur ces deux motifs, et nous sollicitons que la Chambre veuille bien nous donner un délai, parce que nous allons avancer tous les éléments nécessaires pour convaincre du bien fondé de cette procédure. Deuxièmement, donc, j'ai dit donc, la motivation de la Chambre, il faut le rappeler, et l'innovation, le caractère innovateur de cette Chambre par rapport au retrait des charges, quand on sait quelle est la jurisprudence dans la plupart des autres chambres, elle est il faut qu'on puisse être autorisé à expliquer qu'il y a matière à reconsidérer cette décision d'arrêter tout procès, tout droit au procès, uniquement parce que le procureur n'est pas coopératif, parce qu'il pense qu'il n'a pas assez de charges. Mais qu'ils le disent, qu'on permette au dual status témoin et aux autres témoins que nous avons entendus, qui peuvent vous dire sur des points techniques très clairs qu'il n'était pas possible d'avoir des contacts avec le gouvernement du Soudan, technique à l'appui. Donc nous disons que nous sollicitons de pouvoir faire cette requête de reconsidération pour injustice et pour quelque part un raisonnement qui ne correspond pas à la logique des textes des devoirs du procureur et du plein pouvoir juridictionnel de la Chambre dans son impérium. Et enfin, je terminerai juste pour dire qu'en ce qui concerne les expurgations, mais ce n'est pas la première fois que j'ai cette pensée, mais ce dossier, au stade de cette affaire, j'en étais plus que jamais persuadée. Les expurgations, mais quels sont les objectifs des expurgations? C'est de protéger la vie, la santé morale et physique des victimes et des témoins. Donc, il faut que ça soit lié directement, concrètement, à un risque concernant une victime ou un témoin. Mais dans beaucoup des cas ici, il n'y avait pas ce risque-là. Il y avait quoi? Il y avait donc la volonté de sauvegarder la coopération, c'est bien, de sauvegarder le secret avec les négociations entre le gouvernement et les autorités, c'est bien. Mais le fait de dissimuler, d'empêcher le public, les victimes, dans ce cas tellement complexe et tellement évolutif, où, pour parler familièrement, le procureur a tourné sa casquette, on ne sait même pas quand exactement, puisque jusqu'en 2022, 30 mai 2022, il disait qu'il n'y a pas à enlever le mandat d'arrêt. Donc nous disons qu'il est capital que la pratique des expurgations revienne à leur source originelle. Protéger un intérêt concret, une victime ou un témoin d'un danger concret, mais pas biaiser, oblitérer la compréhension par le public, par les victimes, de l'évolution de l'affaire, des éléments. Pourquoi le procureur a tourné casquette? Sur quelle base? Pourquoi, après avoir dit traiter le gouvernement du Soudan comme des criminels et que par conséquent Askanita pouvait être attaqué parce que c'était une target, c'était une bon, je veux d'abord que le fait que le général, que Banda soit un général, soit connu, soit public, et ça c'est une fonction officielle. Bien sûr, on n'a pas produit les extraits de médias, mais il suffit d'aller dans Internet, et tout le monde sait qu'il est le général. Et c'est très courant. En Afrique, combien de rébellions sanglantes, de guerres sanglantes entre le pouvoir et les rebelles se terminent par une négociation, par un partage du gâteau, parce qu'il faut dire ce que c'est, les délices du pouvoir, et puis tout d'un coup, il n'y a plus de droit. Et tout d'un coup, le gouvernement devient un saint, l'accusé devient une victime, et les vraies victimes qui ont perdu leur vie, qui ont perdu leur raison, qui ont perdu leurs moyens de survivre, elles ne deviennent rien.
Madame Sissi,
Voilà, je voulais juste dire... Ah, ok.
Counsel, I
Yeah.
gave a very clear instruction as to the restraints and constraints of this hearing and the subject matter, and you're straying far from them
Okay.
at this point. So I would please
Je
encourage you to, I appreciate the importance of your observations, and you're speaking on behalf of victims, but I would ask you to bring your remarks to a conclusion. I believe you've very thoroughly presented the position of the victims, so I'd ask you to bring this matter to a conclusion. Your remarks, please. Thank you.
Je vous remercie, Madame la Présidente. Je vous présente mes humbles excuses. Mais quand on est en contact avec les victimes et qu'on voit leur état, on ne peut pas s'empêcher d'être touché. Mais j'ai essayé de me cantonner au retrait des charges. Seulement au retrait des charges, mais pleinement, sous tous ces aspects, la problématique du retrait des charges. Donc j'en ai fini, Madame le Président, et je réitère mes excuses. Mais encore une fois, je me suis focalisée sur le retrait des charges. Merci, Madame le Président.
Merci beaucoup, Monsieur Sissi, and I thank the representatives of the victims for their representations today on behalf of the participating victims. We'll now turn to the defense.
May I please the honors, I will respond to some of the points, raise several points, and thereafter I will ask my co-counsel, Mr. Thomas Oboff, also to make some brief submissions before we conclude. Your honors, when I came here today, there are problems I did not anticipate. You heard very much about the African Union. And I can say respectfully that we at the African Union, being the victims of Westphalian order, the Rome Statute became the very first independent treaty that we joined as subjects of international law, and we guard that jealously. And obviously the African Union cares very much about what's going on in Darfur and peacekeeping operations generally. I've been in all the battlefields, and for one of the first counsel from the ICTRO to Special Court of Sierra Leone to the ICC Central Africa. I've also advised governments in the continent as a very senior lawyer in the continent and a traditional chief. And one of the key significant personalities at the African Union. On the 11th of February this year, I was on the floor of the Security Council to talk about Africa, about cultural factors in international law. And with that said, the case before you and the case before ICC is an individual criminal responsibility. African Union has not made any complaint here. African Union is concerned about the genocide in Air Germany, El Fasher, that exterminated millions for which General Banda and others are fighting to protect. That is what the African Union is interested on. Furthermore, your honors, about fairness, it was Justice Jackson of Council of US at Nuremberg who said, fairness is not an attribute of weakness. And when we look at these accused, we should be fair to them. Because if we are unfair to them, we'll be like putting a poison chalice to our own lives. The prosecutor, in this case, has done what he's mandated by the Rome Statute to do. And that's what Africa and the African Union, in particular, the majority in the Rome Statute architecture, 33, and many more now coming, came because they saw the possibility of fairness, a court, instead of the court of the Westphalian orders, the colonial court, they saw a court that will respect the independence of the judiciary, of the judges, protect that independence, guard jealously, and protect the independence of the prosecutor. And that's why we continue to stand resolutely, Africa. And I think it didn't stand because Africa can stand, talk on their behalf. We will respect and protect the independence of this court and the judges and the prosecutor. And will continue to do so resolutely. As we live here and we hear these submissions, the African Union is minded to protect and to say so loudly, because we will no longer be guided by the spirit of Westphalian order that uses the African Union as a faceless institution which can be used to whip out emotions. Your honors, the prosecutor, we agree with the prosecutor in the filing that they made on the 5th of October 2023, in which the prosecutor stated, and I quote, the prosecution is responsible under the court's legal framework for framing the charges upon which an accused is brought to trial. It must also ensure the effective investigation and prosecution of crimes in full respect of the rights of accused persons, and of the interests and personal circumstances of victims and witnesses. In discharging these duties, It is uncommon on the prosecution to seek to withdraw the charges pursuant to Regulation 60 of the Regulation of the Office of the Prosecutor if it considers that the evidence does not support the charges in the requisite standard of any stage in the proceedings. A few weeks ago, the Bureau of this court, the plenary of this court, you, your judges, you made a clarification on the question of withdrawal and took a principled decision on which you are acting now. I do not know whether my colleagues actually read the decision that you took about the amendment, the clarification. And I think the withdrawal before your orders is consistent with the collective decision of all the judges of this court to say that the application will be brought before you for withdrawal. Your Honors, I must say something with regard to this specific case. I'm grateful, Your Honors, that you gave me the responsibility to appear before you and defend the interests and the rights of General Banda. You did that. You heard from General Banda himself and made your order that you accept and that he has appointed me and my team to represent him. We'll follow the mandate faithfully, ethically, and responsibly. When you ordered that we could contact him, facilitation with General Banda, we did that. And we reported. I can say clearly that the records of this court, because justice is not just about victims only. They will not understand that we work consistently for years.
Counsel?
Yes.
Chief Taku, please, if we could return to the issue at hand, which is not the review of the efforts to interview your client. Please,
yes.
Address your comments solely to the issue of the withdrawal request of the prosecution, please. Thank you.
Well, I take the orders from the court. I was just replying from very emotive submissions, very emotive as they are, but they did not concern the substance about the powers of the prosecutor to withdraw, which are attribute of fair trial, which make this court strong, that persons outside and victims in crime bases, especially in Africa, where this court has been for the past 20 years or more, we know that they will no longer bring cases to the court for trial, which will collapse even at the pre-trial, and many have collapsed. And the prosecutor is right to remedy this situation and bring before you and commit the resources of this court only for cases for which they can secure a conviction or even a prima facie case. The prosecutor has made the assessment, it's wholly within the power of the prosecutor. And I think this is a great occasion in the history of this court that people will know that the prosecutor will prosecute vigorously people against whom they find evidence, individuals, and people that the evidence does not meet the standard, the required standard, to go on trial, the prosecutor will graciously withdraw. Both are victories for this court. It's a discharge of the responsibility of the prosecutor. And I think the prosecutor exercised that right judiciously, reasonably, and I explained it. The prosecutor, I listened to the prosecutor report to the Security Council. There's an additional factor that they said that evidence came to the prosecutor, exculpatory evidence came to the prosecutor, which the prosecutor thought that reviewed in addition to this, I thought that sufficient or was not enough for them to go on trial. And I think we should respect that prosecutorial discretion, that prosecutorial independence. This is what everybody, every justice seeker, that is the original objective of the Rome Statute. We are not going to go to trial just because we want to show a public show. It will bring discredit to the court. And it will be unethical for any prosecutor to put a person on trial when the prosecutor is quite sure that the evidence is not enough. And it is only the prosecutor alone that can make that calling. And the prosecutor made that calling. And your honors, I totally respect that, and I praise the prosecutor for that. I praise your lordship for reconsidering this decision on this basis. Because at some point, even if they brought that case and started trying, and your lordship saw that the evidence was sufficient, it was collapsing, you will have the duty also to say, look, prosecutor, go and look at this evidence and determine whether they intend to continue. Your honors, I do not intend to take as much time as my colleagues to waste the precious time of the court. I only wish to say, I respectfully thank the prosecutor and thank your lordships for giving me the opportunity to defend General Banda. I also thank the witnesses of General Banda, some of them who are under the protection of the court, and many who are there preparing for him to come. When he said he was coming, he changed it to summons. I thank them, I thank my team, and your honors, I thank the registry that facilitated. For all these years, we're in contact, talking with General Banda, and we filed many times. He was always present, showing the interest to come. There were other factors that prevented, but he was always showing. I thank the registry for that. I thank the external operations. And I thank, on the encouragement of your lordship, we held several meetings with the prosecutor external operations with regard to our mandate, and I thank them. And I hope your honors that this is a very good day for international justice. I pass I ask my colleague, Mr. Boff, to make other comments.
Thank you, Your Honors. And following the guidance from the Chamber, I have cut 80% of what I was going to say out.
Thank you, counsel.
For everyone watching, for everyone in the courtroom, I would like to make this clear. The problems outlined by my learned colleagues today were problems that existed all these years. They weren't something that came anew. Yes, a few people may have passed away, but we have rules to deal with that. New rules have been instituted in the rules of procedure and evidence. It was because of the perseverance of the Office of the Prosecutor in continuing their investigations and continuing their inquiries that made today happen. And I thank the prosecution for its candor and for its professionalism. Just as we were open during these many years with the Office of the Prosecutor since Chief and I joined in 2019 and constantly contacting them, they were there talking with us, and they were open to the extent that they could be, and they maintained the highest level of professionalism while handling this case and dealing with us, with the Chamber, with the registry, and yes, even General Banda himself. Thank you, Your Honor.
Thank you very much, counsel. Unless there's any other submissions, which I would not anticipate, this will bring this hearing to a conclusion. The Chamber has heard all the observations and has taken note of them. The prosecution is to take the steps as indicated in the order. Prior to adjourning, I would like to thank the staff, the security, our court registry, court reporters. I'd like to thank those in the public gallery and those who may be following online. At this point, this hearing is adjourned.
All rise, veuillez vous lever.